Okay. Excuse me, we are about to start, so if you can find your seats, please. Yes, our next speaker is Jon Wessel-Aas, who is an expert on media law and a lawyer and an author, and I just read his book on copyrights in online media, which is great. And so, please welcome Jon Wessel-Aas.
Thank you. This is obviously a very snappy congregation. So inviting a lawyer, I don't know what you were thinking about, you know, but we'll try. I was given the title. I had a little say as well, but I was given the title here, Do's and Don'ts when publishing personal images and videos online. I've inserted a little part here in all humbleness because I can give you some do's and don'ts, but I don't have all the answers, and there are also some challenges, which I'll try to point to in this snappy little overview over quite a complex area. Because there are challenges there as well, where I don't think anyone has the complete answers yet. And lawyers, you know, we get our answers from the courts, basically. That's how it works. And until the courts have tried a question, we don't really know what the answers are. And this is an area, like many areas in life, but an area which is moving faster than the court cases are moving. So there is some time lag there. Now, the bottom line here is we're talking about publishing. We're talking about personal images or privacy rights. It's basically, the bottom line is freedom of expression versus the right to privacy. It's that simple and that complex. And I've, as my title indicated, I'll be speaking in a European perspective. We have speakers and other guests from outside Europe, and there are, of course, differences here, especially when it comes to the protection of privacy. I think Yusuf also mentioned that in Europe he notices that people are a lot more conscious about it, and that is also reflected in European law, which is, in this area, very complex, fragmented, and hierarchical. And I won't drag you through all this. I just want to point out why it's difficult in 25 minutes to take you through all of the details here. But just to give you an overview, we have community law in Europe, the EU law, with its own Charter of Fundamental Rights, which protects both freedom of expression and the right to privacy and data protection. And the Council of Europe countries, which comprises a lot more countries than the EU, but includes all the EU member states. We have the European Convention on Human Rights, which also protects the freedom of expression and the right to privacy as equal human rights. Some countries have their own constitutions, which protect one or both of those rights in constitution as well. And then you have national sort of detailed legislation, which of course varies quite a lot within Europe, at least if you read the law. But because there's a hierarchy here in law, we have a principle called the lex superior, which means that things like the European Charter on Fundamental Rights, the European Convention on Human Rights, is above national legislation. No European countries can practice legislation which isn't in order if you challenge it against the European Charter or the European Convention on Human Rights. So that makes it a little bit easier to be a lawyer cross-border as well in Europe in this area, because the bottom line is that we're all bound by the same basic principles here. And just to visualize, you're not going to see any more references to laws or anything, or jurisprudence, but from the European Court of Human Rights, this pretty much sums up, call it the dilemma, or the starting point. You can read it yourself, but basically what the court says here in a famous case in this area with Princess Caroline of Monaco, von Hanover against Germany, where the court establishes that one's personal image is one of the chief attributes of one's personality and is, in short, is a specially protected area of privacy, the personal image of all of us. On the other hand, freedom of expression includes the right to publish photos also of persons. Of course, that's the outset. Now, in all these cases where these rights collide, whenever a journalist or a media organization publishes pictures of people, they're exercising their freedom of expression, but the person's personal image is also protected against being made public without their consent at the outset. We all have a right to control the use of our private details and our personal image. So basically what happens when these cases come into the court, and I have to be very rough here, there are so many nuances in every case, but what the courts will be looking for here to say which rights should prevail in this particular case, because none of their rights prevail over the other at the outset on a general level. The basic question is the use of this private information or this personal image of the person in question, is it publicized in a context where the publisher at some level is contributing something to public debate? Is there any public interests? And anyone who's a journalist knows that public interest is an important defense against attacks on freedom of expression in many fields, here as well. So is there, in this context where you publish this image, does it have public interest? Does the topic have public interest, and does the personal image or the identification of this individual, is it relevant to that public interest in the particular case? And they also, in other contexts, this is, typically when you see pictures, it's obvious it's a picture of a person, it's their face. Politicians, all these public people, they don't have anything to say in that sense. That's obviously it's in the public interest, they're in their official capacities. But whenever there's a private person who suddenly, for some reason, a journalist decides that their image is interesting, maybe they're indicted for something criminal or something, or maybe something happened in the streets, or maybe just there's a crowd somewhere in the streets. The person that's in the picture and themselves aren't that important, but their images are included. So there's another notion. First, this public interest, and then what legitimate expectation of privacy can this person have in this situation? I mean, if you go out in the middle of the street, even though you're a private person with no official role, if you go out in the street and you pull a gun and start firing, you don't have any legitimate expectation of privacy. You have to accept that people are going to take pictures and publish those pictures about you because there's a public interest and you have no legitimate expectation. Now, that's the bottom line when it comes to this. But of course, online journalism, when things are quick and snappy, that's not always respected, or a lot of this journalism doesn't go through the normal sort of editorial appreciations as you usually have. It's a bit too quick sometimes. I took a little snap from earlier today when Yusuf showed some images from this arrest, and of course that's a typical sort of situation. I'd say normally you wouldn't publish those kind of pictures of the people there if you can see their faces and they're identifiable at that stage where you don't know, are they innocent, are they not? You would wait. in a normal sort of editorial context. You'd get those pictures in and you'd evaluate the situation. Maybe you would publish them, maybe you wouldn't, but you'd have to do a lot of small research, some check questions before you publish it. And sort of real-time publishing, well, that's a challenge. This is quite a new case. Well, it's not a case. I've made a case of it. But it's from the Daily Mail in Britain, which had an article with a huge picture gallery from the streets in the cities in Britain, in England, of drunkenness. Normal people looking, you know, how people do when they're too drunk. And you just see some examples down there. Private persons, girls sitting, you know, with their skirts a little bit too high up and all the makeup running, and a friend trying to console them. Maybe their boyfriend broke up or they just puked because they had too much to drink. But this is, at the outset, obviously, legally, I think also Yusuf said something about that. In a European context, you have a right to privacy also in public spaces, as long as you're there in a private capacity, as you are if you're out having a party or partying too much, until you do something criminal. These people, and there are lots of more pictures, and they were completely identifiable in many of these pictures. And I'm presuming that none of them consented to having this published. I think this is an obvious violation of their privacy. But then you have, this is from my Twitter account, where I made that black stripe across the faces now so that I don't step into the same pit as a Daily Mail. But I posed the question to this guy, Paul Bernal, who's an academic in the UK who deals with privacy law. And I asked him, you know, isn't this a problem? And I'm referring to the European Convention on Human Rights, Protection of Privacy. And of course, he agreed with me, but in Britain, the national legislation isn't very clear on that. The privacy notion isn't very clear. And we had a further discussion, and I said, don't they get problems? Because the Daily Mail does this type of stuff quite often. Photo galleries of life in the streets, especially when people are doing things that they probably never would consent in anyone publishing. And his answer was, well, it costs money to sue the courts. And that's why most of the cases we have, and in Strasbourg as well, in the Human Rights Court, the biggest cases there, they're cases where the complainant is the Princess of Monaco with lots of money. She can afford to bring her cases all the way up. Of course, the normal drunk girl in the street there who probably spent all her weekly earnings on that binge, she's not going to sue the Daily Mail through 3 courts, instances of court in the UK, and then further on to European courts to try her rights. So obviously, what I'm saying here is that don't look to how some of the big media, some places in Europe, actually practice this, because it doesn't mean that it's right. And there are lots of court cases, and at least in the Norwegian jurisdiction, we have I'm a lawyer for quite a few of the media here, like Jon Arne, who spoke just before lunch. And he knows that Norwegian media are aware of this distinction. And there are challenges with the new sort of snappy online journalism. And I'm not going to say any more about sort of the blatant publicizing of personal images, apart from the main rules that I've outlined here. We're going to move on to some other challenges connected to this with the online digital journalism. Well, first of all, just a note of caution. This is just an example from some Norwegian media outlets about, you know, when there's leaks of Snapchat pictures of girls who aren't very well, you know, or much dressed, who they thought they were sending to a sort of private little group, but then someone screenshotted them and made huge databases, and there's a leak. Happens in all countries. We've had occasions here where some media organizations covering that story, which obviously has public interests, have had screenshots of these, which have been online publicly, but they've just published the screenshots without doing anything to anonymize these girls themselves. And there's no excuse in this context saying, well, look, they were publicly available on some obscure site, but they were publicly available already, so why do we have to anonymize them? That's not a defense. You have responsibility for your own publication, and very rarely is it a defense that an image is already public, unless it's so public that it's meaningless to sort of try to protect their privacy anymore. But at the outset, it doesn't matter. But it doesn't necessarily matter if the girl, in this case in question, has actually published it on her own profile in a social media, because she hasn't necessarily agreed to have it published on the front page of a national newspaper. European privacy law gives you at the outset the right to control where your private information and where your personal image is allowed to be published as well. Of course, the more consent you give to have it published many places, you're losing the expectation of privacy, of course. So this is all nuances, but I'm talking about the bottom line, the main rules, the outset. But obviously, if we're talking about pictures that you haven't taken yourself as a journalist, this online world does give a lot of possibilities. This is another client of mine called Dagens Næringsliv. It's sort of the financial paper in Norway. This is not one of the financial byproducts. This is a Friday magazine, which is sort of about fashion and other stuff. And they had a huge article on the Kardashians, especially Kim Kardashian, but the Kardashian dynasty. And the article in the magazine on the inside was about how they've managed to make a trademark of themselves as persons, not least by using social media. Kim Kardashian, her Instagram account with selfies, many selfies every day about everything she does, and has created that, billion-dollar industry basically on her own image. She doesn't have any more sort of claim to fame than that. So they decided, and we're not going to go into the copyright. That was the question here, which I said was okay, because to illustrate this, they had the rights to this photograph that you see here on the cover, but if you close up, and even closer, you'll see that this is the pixels in this photograph are tons of small selfies that she's posted on her public Instagram profile over the times. And we're not going into copyright today, but the copyright question was, of course, she has the rights to those photographs. Could they use the right of quotation or other rights to use them in this manner? And my answer, and they haven't been sued yet, obviously, because the Kardashians, any publicity they get, they're happy, so they're never going to sue anyone for using those photos. But the answer was yes, they can, because this is a statement in itself, using exactly those images to build up that huge picture of her. But had that been a private person, regardless of copyright, you'd always have to pose the question, can we use this personal image in this context? Does it have public interest or not? Another challenge in the online world, which I think Jill sort of touched upon, is, in the old days, in the printed media, in the classic television where you just saw the picture on the screen, that was what you got as an audience. If you put that black stripe over someone's eyes or whatever in the printed paper, they were anonymized, or as anonymized as the editor wanted them to be. And the audience would have to, that's what they got. Today, there are many techniques now available. I don't even know about all of them, but now you have easily available applications for the idiots amongst the users who don't know anything about technology, plug-and-play applications, which with different types of technology can actually just take away the anonymization. Face recognition, some of you know a lot more about this. There are many ways of doing this, many techniques. This has not been tried in the courts yet, but when I talk to my media clients, I say, I think you have to be prepared that one day you're going to get a case like this, and the courts are going to say, we don't accept it. We're going to treat you as if you published that image completely openly. Although you tried, when you know that all the user has to do is press a button and they get the face, you cannot come to this court and say that you actually anonymized them. And of course, technology is probably going to try and help in that matter as well, but that's one of the sort of challenges I think you're going to be facing quite soon. I don't know of any pending cases yet, but then again, I don't know about all pending cases in Europe either. Another thing with online publication is the right to be forgotten in European privacy/data protection law. I mean, a lot of you heard about the so-called Google Spain judgment of the European Court of Justice a few years ago. And after that judgment now, you know, that Google sometimes, when people request it, in certain cases, they have to remove links to privacy-sensitive publications, you know, that are very old or outdated, where maybe when they were published, it was in the public interest at that time, in that context, but 20 years later, being available on the internet, or to put it like this, it wouldn't be okay to publish it today, in 2017. But if it's still available online, what do you do about that? There we have cases coming up, and I think also the media will have to face the fact that you cannot, in the long run, leave all stuff you've published on the internet unedited for all time. It will be reviewed in present-day conditions, so that someone did some minor offense in a local town in a country one year where maybe they had no legitimate expectation of privacy then, well, they finished, that's 20 years ago, they have a family, they're law-abiding citizens now, they might be able to go to the courts and say, you have to do something about that, take out the name, edit out the face, or something like that. We need times for questions as well. I think I'll skip to there are so many other things I could mention, so this is just a little sort of a teaser. But of course, Jill touched upon this as well, at least she did. When you're in when you're on the internet, but when you're on the internet through these applications, the level on top of the internet, they have their terms and conditions. And we can say a lot about that on copyright and everything. We had our Consumer Council in Norway had a sort of campaign last year where they went through the terms and conditions of some of the most popular apps. Just to, how many words are there in the terms and conditions of these apps? How many pages are there? And you can see the result here. It's, and anyone who's tried to read them who isn't as nerdy as an average lawyer, gets tired, and most people don't read them. But of course, at the outset, when you accept those terms and conditions, you've entered a contract. And there are many things you can say about those contracts. Just to take an example from Instagram. And this concerns copyright, it concerns what happens with images of people you post there, if you do it as a journalist or as a private person. Instagram does not claim ownership of any content that you post on or through their service, they say, and that's fine. you still have ownership. But instead, you do grant them a non-exclusive, fully paid and royalty-free, transferable, sub-licensable, worldwide license to use the content that you post on or through the service. So in other words, you can still use your content yourself, but you've given them this license. So I don't think any of these sort of serious companies have actually used the rights that they have at least not to anything looking like the full extent yet, because they know that that's consumer sensitive. But they have the rights, and this means that whatever you post on there, you've agreed they can sell it to a commercial company anywhere. They can sell it to anyone or sub-license it further to anyone, and your images, they can pop up anywhere with anyone who's made an agreement with Instagram, and they're not unique. You see more or less the same type of terms and conditions in other applications. So that's also something to think about when you post your journalism there. If you've given any promises to your sources saying, we'd like to use a picture of you, in this case we think it's important with the personal touch, but promise we'll only publish it in our outlets where we have control, and we can take it down in a year, for instance. If you put it on Instagram, what have you done? You've given them rights to do what you promised or you didn't have the rights to do with it vis-a-vis your source, which isn't good. And there we are. Another thing, this is just to illustrate a problem which doesn't just have to do with this, but as long as you're working with, devices like this as your tool as a journalist, if we're talking about, now let's forget the publishing of private information, publishing of personal image. Let's say you have that in control. But when you load up, when you take pictures with these devices, what have you done in all these settings? Which applications have you given right to have their hands on your content, your pictures? Do you use iCloud? Where do your pictures automatically, which server do they also, where are they loaded up? Do you have any control about that? About the information security or what rights the owners of those servers have that you're sharing it with, maybe sort of unconsciously? That's also a big issue. And you know that, or some of you know that journalism is, at the outset, exempt from the data protection rules in Europe. Making databases so that you can have databases of sources and stuff without the government having to say, no, you can't do this or that. But you're not exempt from the obligation to have good information security around your databases of sources, for instance. And if you treat your database of pictures, take a picture of a source where you say, we're not going to publish this so they can recognize you. I'm just taking it of you now, and I'm going to take it back home, and you'll do everything right. But maybe you've shared it already through loading it up on your phone with third parties, and where you have no control. Diligent journalists, of course, are aware of these things. Other things there, the last thing I'll mention is also, which also has to do with protection of sources in its essence, is that digital files that you use, whether it's pictures where you've anonymized, or it might be documents you've got from a source, digital files, they have meta tags with information which can reveal your source by connecting dots, or even the name of the source is in the meta tag, and you publish it online without whitewashing it, without the meta tags. You blow your source or blow something else of information about a source that you didn't want to and you'd promised not to do. That's also one of the sort of traps and pitfalls at least in the snappy online world. But those are the things I think, that was my last slide. That was just, as I said, some teasers on some challenges and a few do's and don'ts. And then you said there's time for questions if anyone has any.
Yes, we have time for one question.
Oh no, my client.
Since Jon is my lawyer,
You're going to have some free advice now. Is that what you're trying?
I'm not going
Smart.
to pay. I'm not going to pay for this, Jon.
No, it's okay. It's a freebie.
The one function I'm thinking a lot about that I think is problematic is Facebook Live. And we see that it's used more and more. What I'm thinking about, where you suddenly can have a dramatic situation with a hostage situation, a terrorist stuff or whatever, and it can come out of control. Have you thought about that function?
Well, obviously, I might not have thought about it enough when my answer is that I can't, really, and that goes for a lot of these things, at least as a lawyer. I mean, from the internet came, everyone's always been saying, oh, we need new legislations because everything's different. And as lawyers, especially for you, our job has always been to try and tell them, well, is this really that different? I mean, is Facebook Live, is that any different than someone posting something live through another application or other technology, or the media filming live from the scene of an accident or something else, which you've always done that. But of course, you take precautionary steps. So I don't know. So what you're asking, is it become too easy to do it? Because otherwise, I mean, it's nothing else than just one way of feeding the public with live audio-visual content from what's happening in the world. And of course, there's a challenge there, because you don't know what's going to be on your tape in the next second. It might not be something you would have sent if you'd gone through the editor. But apart from that, I think the only challenge is, again, the snappy, quick, available technology. And of course, who are you sharing the files with if you're using Facebook Live?
Okay, thank you very much. Another round of applause, please.